May I please, your lordship?
Yes. Yes.
Lordship, in item number 7, Lordship, with the consent of the underside, Lordship, this matter may kindly pass over for the date, Lordship. I am for the response.
Mr.
A. Mena,
Mena, the learned counsel for the
petitioner, Lordship.
petitioner, also Mr. B. Deuri, the learned counsel for the respondent number 1, 2, 3. And a prayer for adjournment has been made by the learned counsel for the petitioner, which is not opposed to by the respondent's counsel. Hence, same is allowed.
Lordship, interim is there, Lordship.
Let this matter be listed after 2 weeks on a date to be fixed by registry. The interim order shall continue till next date.
Lordship, date may be fixed, Lordship.
No
We are
date.
some urgency, Lordship. Execution posting pending, Lordship. 11.
Of 14 September.
14, there is a problem, Lordship. Senior will be out of session. Before 14, 11, no? 11.
11 September.
Obliged.
May it please your lordship. Lordship, item number 32, my lord. With the consent of other side, lordship, I am mentioning on behalf of the counsel for respondent, my lord. Can it be passable for the day? We have taken consent from the counsel of the petitioner, my lord.
Item number 32.
32, my lord.
What is your name?
I am R. Karim on behalf of N.I. Chaudhary.
Mr. R. Karim submitting on behalf of Mr. N.I. Chaudhary, learned counsel for the respondent, who seeks an adjournment on the ground of personal difficulty of the conducting counsel for the respondent. He submits that he has informed the learned counsel for the respondent appellant regarding his prayer for adjournment, who does not have any objection to the same. Stop. Hence, the prayer is allowed.
Obliged.
May I please, your lordship? Lordship, I beg to mention item number 4 with the consent of the other side.
Well, I have an objection because by misleading the Honorable High Court, they got the interim order. So I have filed one IA to vacate that order.
We'll file a
The matter is
reply.
very urgent.
Yes, sir. A date may be fixed, your lordship.
The matter can be taken out tomorrow, my lord.
We will file a
Oh.
lordship will file a reply on that.
Because well, they are tenant, he is tenant, I am the owner. And without implementing the necessary party, they approached before the Honorable High Court. And by misleading the Honorable High Court, they got the interim order. And they are extending that interim order.
Mr.
T. Chetri, lordship.
T. Chetri, learned counsel for the appellant, who seeks an adjournment on what ground?
Lordship will file a reply to their vacating petition, your lordship.
Who seeks some time for filing a reply against the which interlocutory application? You have filed a separate IA.
Yes.
What is the number? It is not yet listed.
Yes, it is shown.
This 2848.
IA.
Along with
Along with the main FAO.
Pause this one.
Yes.
Who prays for filing a reply against the interlocutory application filed by the present respondent. On the other hand, Mr. K. Kolita, the learned counsel for the respondent, has submitted that the appellant has obtained the interim relief of stay by suppressing material facts and by not making necessary parties, not impleading necessary parties in the instant revision petition. Hence, he opposes the prayer for adjournment. Stop. However, considering the submissions made by learned counsel for the respondent, the prayer is allowed. Let this matter be listed. 9th of September.
Lordship. Interim may be continued till.
The interim shall continue till then.
But that order is in fact just like.
Short date, shorter date,
Sort of.
3rd of September. Interim shall continue till next day.
That be on 7th, your lordship, if possible. 7th.
Okay, 7th September, interim.
Much.
May I please, your lordship, I beg to mention for listing one contempt matter, lordship. It was last sistered on 15/7, lordship.
Contempt. Court number 8.
These orders, item 15.
None has appeared for the parties on call. It appears that this matter is ready for hearing. Hence, let this appeal be listed for hearing after 4 weeks on a date to be fixed by registry.
Item 16.
May I please, your lordship? Lordship, we are still unable to find the proper address for respondent 124. Your Honor may kindly allow for paper publication.
Miss D. Hajorika, the learned counsel for the applicant, who submits that in spite of best effort by the applicant, the current address of the respondent number, opposite party number 124, could not be ascertained. Hence, she prays for allowing the applicant to take steps for issuance of notice upon opposite party number 124 through paper publication. Respondent number 124, by substituted mode of publication of the notice in the newspaper, the prayer is allowed. The applicant shall take steps for issuance of notice to respondent number 124 by publishing the said notice in a newspaper which is widely circulated in the last known addresses of the aforesaid respondent. The date of appearance to be shown in the notice shall be 30 September. List this matter after 30 September.
Item 17.
May it please your lordship. Directed to take steps I have taken, my lord, but office note does not reflect, my lord. Let me
When have you taken?
my lord, that date, my lord, I have to verify, my lord. Can it be on next week, my lord? I'll just verify.
Heard Mr. P. Sundi, the learned counsel for the appellants, who submits that though the office note dated 24/8/2026 shows that no steps for issuance of notice have been taken by the appellant. However, he submits that the appellant has taken steps as was directed by this court. Stop the registry to verify the same and put up an appropriate note on the next date fixed. Let this matter be
My
listed
lord, can
on
it be after that, my lord? My lord, much obliged.
16th of September.
Item 18.
Wait, your lordship. The matter is ready for hearing, your lordship.
Heard Mr. M. Talukdar, the learned counsel for the appellant, also Miss L. Sharma,
This 1 mile.
the learned counsel for respondent number 1. It appears that this appeal is ready for hearing. Hence, let it be listed for hearing after 4 weeks on a date to be fixed by registry.
Item 19.
May I please, your lordship? Lordship, office note shows that no stay was taken, lordship, but 1/8/2026 stay was taken, lordship. IA and main petition, lordship, both the petition.
Heard Miss
Are they, lordship,
R.
on behalf of AR Shashi.
Heard Miss R. Dev, the learned counsel for the appellant, who submits that though the office note dated 21/8/2026 shows that no steps for issuance of notice by usual mode has been taken by the appellant, however, she submits that the appellant has taken such steps on 1/8/2026. The registry to verify the same and put up an appropriate note on the next date fixed. The registry shall also place the postal track consignment report of notices sent to the respondents by speed post before this court on the next date fixed. Let this matter be listed 11th of September.
Obliged, lordship.
Item 20.
Yes.
I appear for respondent numbers 3 and 4.
How many respondents are there?
Four respondents.
And for the one.
Okay, heard Miss M. Setia, the learned counsel for the appellant. Also heard Miss S. Kotoki, learned counsel for respondent number 3 and 4, as well as Mr. S. Katak, appearing for respondent number 1 and 2. The trial court records I sent a substance. It appears that this appeal is ready for hearing, as the trial court records have been received. Hence, let this appeal be listed for hearing after 4 weeks on a date to be fixed by registry.
Pledged.
Item 21.
I am paying for the respondent.
Ready for hearing? Heard Mr. M. Alamgir, the learned counsel for the appellant. Also heard Mr. D. Chaudhary, the learned counsel for the respondent. It appears that records of the trial courts have.
I appear for respondent number 1, madam. As of the remaining respondents, madam, since 1996, that's the time since the suit was initiated, they didn't appear. The decree was passed expected.
Now what is to be done? Against other respondent did not appear before the trial court.
It's there in the judgment. I can point it out at page 76. They didn't appear. Expertly done.
None.
Occupation. And I have filed the execution procedure, which has been stayed by this court.
None has appeared for the appellant on call. Mr. What is the name?
Bharadwaj. P. Bharadwaj.
P. Bharadwaj appears for respondent number 1. It appears from office note dated 22/6/2026 that notices issued to remaining respondents have been received back without service. The learned counsel for the respondent number 1 submits that the other respondents have also The other respondent did not appear before the trial court also, and the suit had proceeded ex parte against them. Stop. He points out to the observations made in this regard in the impugned judgment. Which para?
Page 76, para 3.
Impugned judgment. Stop. Considering the submissions made by learned counsel for the respondent number 1, the notices to other respondents is hereby waived. Trial court records, I say. Para 70, page
76, para 3, my lord. The remaining defendants failed to contest the suit and accordingly the suit proceeded ex parte against them. Against 1 and 2, the decree was passed. 1 and 2 has filed this particular appeal.
you are
I was for the plaintiff.
okay. The records of the trial courts have been received. Hence, let this matter be listed for final hearing after 4 weeks on a date to be fixed by the minister.
Public.
Chief, I am a couple of minutes late. My item is item number 15, my lord. If any non-appearance is recorded, my name is may be recorded. He is also there.
I am appearing for the petition. I also missed the matter, my lord, item 15.
Show the name of Mr. A. Fukan for
Appellant.
appellant and Mr.
D.N. Bhattacharya.
D.N. Bhattacharya for respondent. After 4 weeks,
I only request a specific date, my lord.
I have filed a cross-examination also, my lord.
okay.
It will be
Specific
listed
date
along
you will
with the-
get in the month of December.
Sometime in September or
So,
any date, my lord.
Let it be after vacation, my lord.
nalagi date at the new 8th of December.
8th. Obliged, my lord.
Let please, your lordship. And this is an application for continuation of delay of 10 days, lordship.
Miss M. Chaudhary.
And lordship, we have already taken steps. And respondent number 1 has appeared. And regarding 1, 2, 3, 4 appeared, lordship. The claimants appeared, 5 and 6. I think, lordship, it is not served. I may be allowed to take steps, lordship, first steps, lordship.
Miss M. Chaudhary, the learned counsel for the applicant. Office note shows that the opposite party number 1 has filed wakalatnama, whereas the notice issued to whereas service report in respect of other opposite parties is awaited. Learned counsel for the what about 2, 3,
Lordship,
4?
these are all claimants, lordship. These are minors, lordship. 1, 2, 3, 4. These are all claimants of same resident.
Learned counsel for the applicant prays for allowing the applicant to take fresh steps for issuance of notice on opposite party number 5 and 6. The prayer is allowed. The applicant shall take steps for issuance of notice on opposite party number 5 and 6 by speed post as well as by usual mode within 7 days from the date of this order, returnable on 28th of September.
1, 2, 4 served, lordship. All are claimants, lordship.
Okay.
All resident, same resident.
No,
1 to 4, lordship.
on the next date I will make that
Lordship.
observation.
Lordship. Must oblige.
Item 24.
Yes.
I'm appearing for the zone of 3 and 4, 6, 7 and 11.
As per office order 21/8/26, no ID card is received till date. It's like respondent 5, 9, and 10.
Already, your lordship, already we have taken
You have
step.
taken steps.
Yes,
We'll heard Mr. U.
thus.
Das, the learned counsel for the appellant. Also heard Mr. S. R. Gogoi, the learned counsel for respondent number 3, 4, 6, 7, and 11. Also heard Mr. T. R. Gogoi, the learned government counsel appearing for respondent number 1 and 2. It appears that from office note dated 21/8/2026 that the service report in respect of notices issued to respondent number 5, 9, and 10 is still awaited. Stop. The registry is directed to place postal track consignment reports of notices sent to the respondent number 5, 9, and 10 before this court on the next date fixed. Let this matter be listed on 14th of September.
Much obliged.
My lordship, as per office note dated 24/8/2026, the notice has been delivered to respondent 3, while service report is still awaited. The LCR also received, my lordship.
Heard Miss M. Setia, the learned counsel for the appellant. Also heard Miss R. Gogoi,
Respondent 1 and 2, lordship.
the learned counsel for respondent number 1 and 2. On perusal of the office note dated 24/8/2026, it appears that from postal track consignment report of notices sent to respondent number 3, it is indicated that the notices were duly delivered to the addressee. As such, the notice issued to respondent number 3 is held to be duly served. Stop. The service of notices on all respondent is therefore complete. However, it appears that the records of the concerned MSC case have not yet been received by ICNIC. The records of the MSC case have already been received. Therefore, this appeal is ready for hearing. Hence, let this matter be listed for hearing after 4 weeks on a date to be fixed by registry.
Chief, kindly may fix a date.
10th of December.
Item 26.
Might please, Your Lordship, as per the office note, neither the AD card nor the unserved notice has been returned back.
Heard Mr. K. Jain, the learned counsel for the petitioner. It appears, how many respondents are
Sole
there?
respondent, Lord.
It appears that the service report in respect of notices issued to the sole respondent is awaited. Staff. The registry is directed to place the postal track consignment report of notices issued to the sole respondent by speed post before this court on the next date fix. Let this matter be listed 15th, 14th of September.
Much obliged, Lordship.
May I please, Your Lordship, I would like to mention item number 18, and we have the resolution number 4 and 5. I could not appear at due time, my lordship.
So what to do?
My humble prayer, my lordships, and that fixed for after 4 weeks.
What is your name?
N. Ahmed, Nuruddin Ahmed.
Show the name of N. Ahmed in item number 18.
Yes, Your Lordship.
Item 27.
May please your lordship. My lord, here in this case, I am the defendant counterclaimant. My cross-examination and the evidence was expunged, my lord.
Why?
Because of fault on the part of my part to appear on
For
5 days
cross-examination.
for cross.
We have filed our affidavit. It may be listed for admission. It is wrongly listed in orders column.
Heard Mr. S.K. Ghosh, the learned counsel for the petitioner, also heard Mr. B.J. Talukdar. B.J. Talukdar appearing on behalf of Mr. B. Deka, the learned counsel for sole respondent,
No, one.
all respondents. He submits that the respondents have filed affidavit in opposition in this case. You have received the copies,
Yes.
and hence this matter be listed for admission hearing. Stop. Let this matter be listed in admission column on 18 September.
Earlier interim order, my lord.
The interim order shall continue. Stay is there,
Yes.
shall continue till next day.
Okay.
Wait, please, Your Lordship. My lord, matter relates to my lord production of additional evidence, my lord, at the appellate stage matter. The petitioner is a plaintiff, my lord. The suit was dismissed, my lord, and against the dismissal, my lord,
Now, why it is listed in orders column?
is supposed to come in admission, my lord.
Maybe listed, but
Otherwise, you are ready.
Right.
Okay, let it come in admission column. Heard Mr. H.P. Gwala, the learned counsel for the petitioner. Also heard Mr. G.J. Sakya, the learned counsel for the sole respondent. It appears that this matter was directed to be listed in admission column. However, it has been wrongly listed in orders column. Let it be listed in admission column on 18th of September.
Obligation.
In this case, my lord, I have taken up notice, steps, my lord, for notice was private respondent, my lord. I have service report, my lord.
Heard Mr. M.A.I. Hussain, the learned counsel for the petitioner. Also heard Mr. T.R. Gogoi. You are appearing for?
6 to 9, lords.
Appearing for respondent number 6 to 9. It appears from office note dated 24/8/2026 that service report in respect of notice is issued to respondent number 1 to 5 is awaited. The registry is directed to place the postal track consignment report of notices sent to the respondent number 1 to 5 before this court on the next date fixed. Let this matter be listed on 14th of September.
Hello. Lordship, appellant was directed to furnish the extra copy to the government.
The petitioner shall furnish requisite numbers of extra copies of the petition along with annexures to the learned government council within 2 days from the date of this order.
All right.
or should we produce the office note to log in?
Yes. Well, what will you do? Respondent number 2 and 3. You take fresh steps.
Lordship.
Mr. What is your name?
ZH Boda.
Z.H.
Bora.
Bora, the learned counsel for the appellant. None has appeared for respondent number 1. Office note shows that office note dated 24/8/2026 shows that notices issued to respondent number 2 and 3 have returned without service. Stop. The appellant is directed to take fresh steps for issuance of notice upon respondent number 2 and 3 by speed post as well as by usual mode within 7 days from the date of this order, returnable on 28th of September.
Lordship. Awesome.
May please, your lordship. As per office of the 24/8/26, no ID card, no answer notice has been returned till date.
Heard
Yes.
Mr. S.R.
Office may be waited.
The learned counsel for the petitioner. Office note dated 24/8/2026 shows that service report in respect of notices issued to respondent number 1 to 4 is awaited. Stop. The registry is directed to place the postal track consignment report of notices issued to the above mentioned respondents by speed post before this court on the next date fixed. Let this matter be listed.
There is an interim order, even continued to further orders.
16 September. Let the interim order continue till next date fixed.
Item 43.
May please, your lordship. My lord, as per office note 24/8/2026, notice was served all the respondent, my lord. Calcium not received, my lord.
Heard Mr. N. Devnath, the learned counsel for the appellant. Office note dated 24/8/2026 shows that notices issued to respondent number 1 has been duly served, whereas the respondent number 2 and 3 have filed their wakalatnama in this case. As such, service of notice on all the respondents is complete. Stop. The registry shall issue a reminder for requisitioning the records of MSC case number 394/2019 from the concerned tribunal. Release this matter again. 25th of September.
Obliged, lordship.
What is your name?
Respondent number 3.
What is your name?
Idas.
Show the name of Miss A. Das for respondent number 2 and 3.
Obliged, lordship.
None has appeared for the applicant on call. Office note shows that the notice issued to respondent has returned without due service. The applicant is directed to take fresh steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 30th September.
Item 35.
Made clear. As per office note, no ID card and service report has written.
Heard Mr. A. Cabra, the learned counsel for the applicant. Office note dated 12/8/2026 indicates that service report in respect of notices issued to the sole respondent is awaited. The registry is directed to place the postal track consignment report of notices issued to the sole respondent by speed post before this court on the next date fixed. Let this matter be listed 16th of September.
Item 36.
Lordship, 27 days delay in preparing this appeal. So
Heard
first day-
Mr. A.T. Sarkar, the learned counsel for the applicant. This interlocutory application has been preferred by the applicant for condoning the delay of 27 days in preferring the connected MAC appeal. Issue notice to the opposite parties. The applicant shall take steps for issuance of notice upon the opposite parties by speed post as well as by usual mode within 7 days from the date of this order, returnable on 30 September.
Item 37.
May I please your lordship, this I for condemnation of delay 142 days lordship.
Same order. Same order. What is your name?
P. Sudhir.
P. Sutia. Council's name P. Sutia. And next date is 30 September. Take steps within 7 days.
Item 38.
My lord, limitation is by 26 days only. my lord.
26 days. L. Sharma. 30 September. Take steps within 1 week.
Bless me.
Item 39.
Condonation.
Yes, my lordship, there is a delay of 17 days. My lord,
17 days delay. M. Setia. Council. Take steps within 7 days. 30 September next day.
Item 40.
May I please your lordship? Lordship, filing the appeal, for filing the appeal, there is a delay of 429 days, lordship. Notice may be issued.
Mr. A.U. Ahmed. Same order. 30 September. Within take steps within 7 days.
Lordship,
Delay of
429 days.
429 days.
Item 42. Supplementary list.
Hello. Order will like home. Only date of delay. Item number.
May I
Yes.
please, Lordship?
What is this?
Lordship, IA was filed for Lordship condemnation delay of 220 days, 2 days, Lordship. But on the last occasion, Lordship wanted to know the grounds of the Lordship review, Lordship.
Yes. Who filed the probate case?
Probate was filed by Lordship.
It was filed by Vivekananda Vasumutari.
Lordship, the
I'm appearing
executor.
for it.
By the respondent.
It
It was granted.
was granted. They also filed one cross case
Cross.
that was dismissed.
They also sought for probate.
They also sought for probate.
Not probate, Lordship, but cancellation of will, Lordship.
Okay.
Cancellation of will. That's what they.
Cancellation of will.
Yes, Lordship. On the ground of Lordship,
Case has been registered.
2 cases was registered in the past same order, Lordship. In one order,
Now this appeal is against review.
against the Lordship appeal, Lordship. Testament of appeal.
Then you preferred an appeal.
Lordship.
They prepared.
We have
You
prepared, Lordship.
appeal against which order?
Probate order, Lordship.
Grant of probate.
Yes, Lordship.
That appeal was dismissed.
The appeal was dismissed.
Then you preferred a review.
A review, Lordship.
Review is delayed.
Delayed lordship 202 days lordship.
On what ground you are preferring a review?
Lordship, the ground is lordship in the review lordship at page number 10 lordship. Here lordship, we have stated lordship, the thing is that lordship, the legatee lordship, he was died at the probate proceeding lordship. Then lordship, the Lanet trial court granted probate lordship in his name and bequeathed all the properties in the name of his mother lordship at that time. Lordship, we have challenged that lordship in the appeal also lordship. But we are the lordship, the legal heirs of lordship, legatee lordship, that we were, our name was not imputed lordship at that time lordship. Only mother's name was imputed lordship. And thing is that lordship, that the testator has two wife lordship. One is the lordship legatee's mother and another was lordship petitioner's mother lordship. The will was lordship, done lordship in the name of his lordship's son from lordship's second wife, which was not lordship the legally.
How many days delay is there?
Delay lordship 222 days lordship.
And what
But
are the
lordship, it
reasons?
was not informed lordship by the advocate at that time lordship. Therefore lordship, from the date of knowledge lordship, when we come to know lordship, from the date of knowledge, it is 69 days.
Yes, Mr. Chaudhary.
They obtained a certificate copy from this honorable court on 7/8/2019,
7/8/2019 lordship.
and they submitted the same to the council on 16/8/2019. And thereafter, they filed this review application along with the relay condemnation petition on 15/11/2019. So almost after 4 months.
Also, therefore also
The
the
4 months
delay of
one-
69 days also from the date of knowledge lordship.
For 4 months, the file was with the advocate. Those delays are not explained. And it is their statement that they have submitted those papers at page 11 of the IA on 16/8/2019. This given it to the advocate
Vivekanand Biswathari
was the executor.
It executed lordship.
and Luna Basamatari,
Luna Vatari is the daughter of the testator.
Udashi.
Udasi is the second wife of the testator.
You are representing all of them.
Yes.
And Lily Basumatari is the first wife.
Lily was
Daughter of the first wife.
daughter of the first wife.
All the petitioners are the daughter of the first wife lordship.
And in fact, that ground my learned friend has stated has already been dealt by this honorable court by the order dated 7/2019. The beneficiary of the will survives the executor. That is the basic point under 105 of the Succession Act. During the probate case,
Okay, we'll
That-
decide the review application.
Gotcha.
Let us decide.
Gotcha.
Heard Mr.
A not lordship.
A. Nath, the learned counsel for the applicants. Also heard Mr. D. Chaudhary, the learned counsel for the opposite party. This interlocutory application has been filed by the applicants in connection with testamentary case number 1/2014, praying for condonation of delay of 222 days in preferring the review application against judgment and order dated 7/3/2019 passed by this court in testamentary case number 1/2014. The learned counsel for the applicant has submitted that the applicant were not informed about the order dated 7/3/2019 by their engaged counsel, and they came to know about the said order only on 7/8/2019, when the petitioner number 1 came to Gauhati. Stop. Thereafter, the applicant took steps for applying the certified copy of the order of which review has been preferred, and instructed the council to file a review application, and in the process the delay of 222 days have occasioned. Stop. Mr. D. Chaudhary, the learned counsel for the respondents, opposite parties, has opposed the prayer for condonation of delay. Stop. He submits that the applicants have not explained the reasons for delay by showing sufficient cause for delay in preferring the connected review application. He submits that even after knowing about the order dated 17/7/2019, there was a delay in filing an application for certified copy, which has not been explained. He submits that even after obtaining the certified copy, the review application was filed after about 4 months of the same, and the said delay has not been explained. Stop. I have considered the submissions made by learned counsel for both sides. Since the review application which has been filed is seeking review of an order passed in testamentary appeal, this court is taking a liberal view of the matter, and regarding the delay, and as such have considered the grounds shown by the applicants in this interlocutory application to be sufficient grounds which prevented them from approaching the court within prescribed period of limitation in filing the connected review application. As such, the delay of 222 days in preferring the review application is hereby condoned, and this interlocutory application is allowed. The registry is directed to register the review application and list the same in orders column after a week on a date to be fixed by it.
Our name may be shown.
Name of Mr. D. Chaudhary may be reflected in the cause list as engaged counsel for the respondent henceforth.
Application for the review.
His name will automatically be shown.
Copy of the review.
Yes. The applicant shall furnish a copy of review application along with annexures to the learned counsel for the respondent within 2 days from the date of this order. This interlocutory application is accordingly disposed of.
Obliged.
Item 43 and 44.
My lord, in both the cases, my lord, till the date, my lord, they have not given address of respondent number 5, my lord. So what to do, my lord? And they are not appearing till the document.
Respondent number 5,
5, only 5, my lord.
you take steps by paper publication.
Okay.
Heard Miss L. Sharma, the learned counsel for the appellant, who submits that the appellant is unable to locate the proper address of respondent number 5. As such, she prays for allowing the appellant to take steps upon respondent number 5 by substituted mode of publication of the notice in a newspaper. The prayer is allowed. The appellant insurance company shall take steps for issuance of notice upon respondent number 5 by substituted mode of publication of this said notice in a newspaper which is widely circulated in the last known address of the respondent number 5. The date of notice, date of appearance to be shown in the notice shall be 30 September. Let this matter be listed after 30 September.
Obliged, my lord.
My lordship, as per office note dated 25/8/26, the notice to respondent 4 has returned due to insufficient address. Lordship, we need some time to ascertain the proper address of the respondent 4.
Who is respondent 4? Who is 4?
Formal is the driver.
You take steps by paper publication.
My
That is
lordship,
better.
okay.
Heard Miss M. Setia, the learned counsel for the appellant. Also heard Mr. K. U. Ahmed, the learned counsel for respondent number 1, 2, and 3. Learned counsel for the appellant submits that the appellant is unable to locate the proper address of the respondent number 4, and as such seeks some more time for the same stop. The appellant shall take steps for issuance of notice upon respondent number 4 by substituted mode of publication of the notice in the newspaper, which is widely circulated in the last known address of respondent number 4. The date of appearance to be mentioned in the said notice shall be 5th of October. List this matter after 5th of October.
Obliged.
46. Item 46.
None has appeared for the appellant on call. On perusal of the office note, it appears that office note dated 25/8/2026, it appears that the respondent number 1 has filed wakalatnama in this case. It also appears that notice has issued to respondent number 4 and respondent number 5 and 6 are duly delivered to the addressee as indicated in the postal track consignment report. As such, the notices issued to respondent number 5 and 6 are held to be duly served. The registry is directed to place the postal track consignment report in respect of notices issued to respondent number 4 by speed post, before this court on the next date fixed. Let this matter be listed 16th of September.
Item 47.
It pleases your lordship. Lordship, in this case, we have taken step on 21/8/26, but registry has not reflected anything, so lordship.
Lordship, reflected on 24, just 2 days back, Lordship, notice has been issued. Lordship, but
Reflected.
one thing, Lordship, just I would like to mention. In the last occasions, Lordship, it's a comes, Lordship, insufficient address. And I also point out, Lordship, to my learned friend, that the correct address is mentioned in this WS of this honor. But second time, Lordship, notice has been taken, step has been taken in this earlier space, earlier address.
Same address.
Same
No,
address.
lordship, we did not find any different.
I have to.
He was supposed to give us the address.
Lordship.
He did not give, so but since the 15
In
days was
on
given-
record, Lordship. Can you see this WS, Lordship? I have.
Lordship, the record goes back. We do not get the record, Lordship.
Lordship,
He was supposed to give me.
Lordship,
So without,
it is a record. Record is there, Lordship. Today morning, I have also seen, Lordship.
Where is the address, proper address?
Lordship, in this WS has been filed by this owner. In the WS,
Where is the WS?
Lordship, it is on record.
Some.
Potom 8%. Potom permanent. Yes. Lordship, after claim petitions, this is WS there. And in WS, Lordship, there is an affidavit. In the affidavit is mentioned, Lordship, in the address. And that address, Lordship, is, I think that is correct.
Whose written statement?
Lordship,
Written statement by whom?
Honor,
What is his name?
Simon Kalita.
Heard Miss R.D. Majumdar, the learned counsel for the appellant. Also heard Mr. I. Hawk, the learned counsel for the respondent. It appears that on the last date, time was granted to the learned counsel for the appellant to ascertain the correct address of respondent number 2 and take fresh steps on the said address. However, the learned counsel for the appellant submits that the correct address was not furnished by the counsel for respondent number 1 to the appellant. On this, the learned counsel for the respondent number 1 submits that the correct address of respondent number 2 is available in the affidavit annexed along with the written statement which was filed by the respondent number 2
but it is the same address, Lordship. We
before the
address.
Tribunal. The appellant shall take steps in the address shown in the said affidavit, that is Shri Simanta Kolita, son of late Hemen Kolita, resident of village Bhavanipur, Horipur, post office Bhavanipur, police station Borpeta, district Bajali, pin code 781352. You see whether in this address you have taken steps on.
Okay. Okay, Lordship.
The learned counsel shall verify whether steps taken by the appellant is in the same address or not. And it if it is found in negative, then the appellant shall take fresh steps for issuance of notice upon respondent number 2 in the above mentioned address within 7 days from the date of this order, returnable on 30th of September, list accordingly.
Highly obliged.
Highly.
May I please be Lordship? Lordship, according to office note dated 25th of August 26, LCR has been received. And in respect of R2, left without instruction, who is the owner, and R3 addressee left, Lordship. Since this appeal is on quantum, Lordship, their name may be struck off, Lordship.
I am for respond number 1, Lordship.
Striking out prayer.
Lordship, regarding striking out, so far as owner is concerned, Lordship, it's a necessary party, Lordship. Because we are the indemnifier only, Lordship. Owner is a necessary party, Lordship.
It is on a quantum, Lordship.
We are liable to pay only when owner is liable to pay, Lordship.
But you were directed to pay.
Yes, Lordship.
It is only for enhancement, Lordship.
The present, on what ground you are seeking enhancement?
On earlier 50% was paid, Lordship. The income of the deceased. Total is paid. Total is paid, Lordship. And
No, on what ground you are seeking enhancement?
enhancement is for the income and interest, Lordship.
Income was wrongly assessed.
Yes,
And interest.
interest, Lordship.
Okay. This owner may not be necessary. Heard Mr. A. Agarwala, learned counsel for the appellants. Also heard Mr. M. Chaudhary, the learned counsel for the respondent number 1. Office note dated 25/8/2026 shows that the notices issued to respondent number 2 and 3 could not be served. Stop. The learned counsel for the appellant submits that since the appellant is mainly aggrieved with the quantum of compensation awarded to them, appellants are mainly aggrieved with quantum of compensation awarded to them. The presence of owner and driver of the offending vehicle may not be necessary. Hence, notice to them may be waived. The prayer is allowed. It appears that the records of the concerned MEC case have been received. Hence, this appeal is ready for hearing. Let this matter be listed for hearing after 4 weeks on a date to be fixed by registry.
Lordship, since it's a case of quantum, Lordship, may be placed before the local Lordship. Local.
We'll have a discussion and let the court know.
Maybe placed, Lordship, before the local, because it's a quantum again.
We'll let the court know in 2 days.
Or when insurance company is ready, you take that opportunity.
Yes, we'll discuss and let the court know, Lordship.
No, we are fixing it before Lok Adalat.
If it fails, it will come
Okay,
again.
yeah.
A prayer is made by learned counsel for the insurance company that since the issue involved in this case is only with regard to the quantum of compensation awarded to the claimants, the matter may be listed before the ensuing Lok Adalat. The prayer is allowed. Let this matter be listed before next Lok Adalat.
12th of September.
Date has been notified.
Date at 12th September is.
Okay,
12th,
next no.
Item 49.
My lord, service is complete upon respondent 125, my lord, and 6 is Dabber, my lord. And we have filed appeal on the ground of quantum, my lord, so he is not necessary party, so he may be deleted from the list.
Heard Miss L. Sharma, the learned counsel for the appellant. Also heard Miss M. Ghazlu, the learned counsel for respondent number 1 to 4. The learned counsel for the office note dated
25/8.
25/8/2026 shows that notice issued to respondent number 5 was duly served, whereas notice issued to respondent number 6 could not be served. Learned counsel for the appellant submits that since the instant appeal is mainly directed against the quantum of compensation awarded to the claimants, the presence of respondent number 6 may not be necessary for adjudicating this appeal. Hence, she prays for striking out the name of respondent number 6. The prayer is allowed.
My lord, case is ready for hearing, my lord. PCR coming.
This appeal is ready for hearing. Accordingly, list it for hearing after 4 weeks on a date to be fixed by registry.
May I plead your lordship? In this case, service is completed. LCR has been received.
Heard Ms. P. Sharma, the learned counsel for the appellant. Also heard Mr. A. Agarwala, the learned counsel for respondent/claimant. This appeal is ready for hearing. Hence, let it be listed for hearing after 4 weeks on a date to be fixed by registry. None has appeared for the.
May I please? Lordship, as per office note dated 25/8/2026, Your Lordship, service has been completed.
Mr. S. I. Akal appears for the respondent. Office note dated 25/8/2026 shows that the notice issued to respondent number 3.
Lordship, it would be respondent number 2. There is a 2 respondent.
Respondent number
There
2
is a mistake.
has been duly served. Hence, the service of notice on all respondents is complete. Let registry.
Lordship, I pray for a date because
Stop.
in this case, Your Lordship, I
The-
file an IA
the
for
registry.
releasing the 50% deposited amount.
Is there
That
any
is not
stay?
take with the record.
Is there any stay?
Yes, Lordship.
The registry shall issue reminder for requisitioning the records of MAC within bracket D case number 9/2022 from the concerned tribunal. Let this matter be listed for hearing.
Orders follow. Along with the IA number
Here.
28,
23rd September
Lordship, along with the IA number 2847.
and along with IA number
4726.
2847/2026.
Deeply.
Item 52.
Made Lordship, as per latest office note, notice is unserved, Lordship, and return back to registry.
How many respondents are there?
Respondents, 3 respondents.
Heard Mr. J. M. Sulaiman, the learned counsel for the appellant, on perusal of the office note. This appeal is for what? You are the owner of the vehicle.
Not lordship. I'm not owner of it. I'm opposite party. I'm not owner. Not driver also.
Who are you?
Implicate me. Opposite party implicate me in the case. Actually, I'm not connected in this case, lordship.
Why you are directed to pay the compensation?
That is why I came here, lordship.
You are not the owner of the offending vehicle.
Not owner, not driver also.
Office note dated 25/8/2026 shows that though the notice issued to respondent number 1 has returned without service, however, as regards the other respondents, the postal track consignment report of the notices so issued indicates that the notices were duly delivered. As such, the notices issued to respondent number 2 and 3 is held to be duly served. As regards respondent number 1 is concerned, the appellant shall take fresh steps for issuance of notice to respondent number 1 by speed post as well as by usual mode within 7 days from the date of this order, returnable on 30 September.
Now, please, your lordship. As per office note dated 25/8/2026, service is completed.
Heard Ms. P. Sharma, the learned counsel for the appellant. As per office note dated 25/8/2026, it appears that as indicated by the postal track consignment report of notices issued to respondents number 1, 2, and 3 by speed post, the said notices were duly delivered to the addressees. Hence, the notices issued to the respondent is held to be duly served. The records of the concerned motor accident claims case have been received. Hence, this appeal is ready for hearing. Let this appeal be listed for hearing on after 4 weeks on the date of the fixed parages.
Item 54.
May I please elapse? In this case, your lordship, by order dated 24/7/26. Yes. Your lordship, by order 24/7/26, issued notice upon the respondent also pass an interim order in the IA, your lordship 24323 till returnable date on 14/8/2026. I have already taken step. This speed post as well as usual process. On the 14/8/2026, the matter was listed before the Honorable Court number 20. But due to sudden illness, the matter was deferred, all the matters.
Okay, heard Mr. S. Islam, the learned counsel for the appellant. Where is the appeal? Appellant. On perusal of the office note dated 11/8/2026, it appears that service report in respect of notices issued to the respondent is awaited. The registry is directed to place postal track consignment report of notices issued to the respondent by speed post before this court on the next date fixed. Stop. The interim order granted on 24/7/2026 in the connected interlocutory application shall continue till next date. List this matter again. 16th of September.
Yes.
Yes, Mr. Item 1.
May I please? This appeal has been preferred by the victim, my lord, claimant, and my lord, the case is ready for hearing, my lord. LCR has also received, my lord. So appeal also may take this matter for final disposal, my lord.
We have also filed a cross objection.
Possible.
Okay.
Cross objection
Cross objection is
2020.
okay.
Cross objection.
In cross objection service is complete.
It didn't get closed.
So objection for you, my lord.
You are appearing for claimants. Claimants. How many claimants are there?
My lord, singular, my lord. This
What?
the
Two?
permanent disability case, my lord. Injury case, my lord.
2 and 3.
2 and 3, my lord, we have strike down because that honor and my lord, we didn't find out the address. That's why our basic prayer is.
Case also, they might not be necessary, Lordship, because we are not challenging the that we are not liable.
Your
We are only quantum.
Quantum. Okay. Heard Mr. S. Shamaria, the learned counsel for the appellant in MAC appeal number 239/2021, as well as respondent in cross objection number 4/2022. Also heard Ms. Adi Mujumdar, learned counsel for the respondent insurance company in MAC appeal number 239/2021, as well as cross objector in cross objection number 4/2022. It appears that the appeal is ready for hearing. It also appears that by order dated 18/6/2026, the name of respondent number 2 and 3 in the appeal was struck off. Since the cross objection, full stop, since the cross objection is also directed against the quantum of compensation awarded to the claimant, the presence of owner and the driver of the offending vehicle may not be necessary in the cross objection, in deciding the cross objection also. Hence, the Respondent number 2 and 3 in cross objection are also not required to be notified. Stop. This appeal and as well as cross objection is ready for hearing. Let it be listed for hearing after 4 weeks.
My lord, I
One-
proceed please to give any date, my lord.
December.
10th of December.
End of December.
10 December.
10th. April.
Alia, alia.
Hopefully, November.
Madam, may be possible for the time being, Lordship. My senior lacks in another court, Lordship.
What is the issue?
Well, they have filed an application, my lord, under section 301 of the Indian Succession Act for removal of the executor of the will, my lord. My lord, there's a will. My lord, the respondent number 1, he is the executor, my lord. Now they have filed his application so that we may be removed from the post of from being an executor of the will.
On what ground?
My lord, they have cited that, my lord, if my lord comes to page number 22 of their application, my lord, this is the will, my lord, second page of the will. Here, my lord, it is stated that the cost of the probate proceedings would be
My lord.
Yes.
Well, as per last order, my lord, the Standing Council, Punjab National Bank, he was, my lord, directed to produce the records pertaining to the account, my lord, left behind by the deceased. So accordingly, we have served him a copy, my lord, of the order.
Why? Why it was directed?
Because, my lord, they say, my lord, they are not able to, they could not file the probate case as per the wish of the deceased because of my lord, dearth of money. He is not able to, my lord, the file the probate case because of the stamp duties and all. So that is their stand. But so far as the will is concerned, my lord, that is clearly written that the money left behind in the account, my lord, would be used to, my lord, file the probate case. So accordingly, my lord, we served him notice earlier to file the probate during the limitation, my lord, is over. But he replied back, well, he is not able to, not in a position to file the probate because of the money involved in this case. That is why, my lord, he has refused, my lord. So obviously, my lord, because of that situation, we have filed this application for removal of the executorship, my lord. So he is clearly, my lord, going against the will of the deceased.
How much money is there in the will?
That we don't know, my lord. We don't know because it is clearly stated in the will that the money is only to be meant for the probate case and also for Shraddha ceremony of the deceased. That is clearly written. That is why, my lord, this question arose whether how much money is left behind by the deceased. They file an affidavit, and the statement showing in that affidavit is, my lord, prior to his death. After his death, my lord, what amount was there, they did not, my lord, inform this honorable court. That is why on another coordinate bench, my lord, on last occasion, was pleased to direct the branch manager, my lord, of the bank.
But bank is not a party. Who took these steps?
My lord, we were directed, my lord.
Have you taken steps?
Yes, we have taken the steps. So, my lord, let it come another day, my lord. Let them appear, branch manager. We'll inform them again, my lord.
My lord, if I may submit, my lord. My lord, we had furnished a bank account, bank statement, my lord, in our affidavit in opposition. My lord, that is in page 45, which reflects transactions up until 14/12/2020. Now, my lord, the testator, my lord, he died on 17/9/2021. Now, my lord, after his death, my lord, no one has access to the bank account of the deceased. Hence, we could not produce. Subsequently, my lord, to have access over this bank account, my lord, the legal heirs would be required to file a application for succession, my lord. Now, my lord, as per the provisions as laid in section 370 of the Indian Succession Act. My lord, if I may read, my lord. Section 370, restriction on grant of certificates under this part. A succession certificate hereinafter in this part referred to as a certificate shall not be granted under this part with respect to any debt or security which is a right is required by section 212 to be established by letters of administration or probate. Now, my lord, this bank account is a subject of the will. Hence, my lord, we cannot file a succession application to have access to this bank account. Hence, my lord, it has become impossible. My lord, there is another provision, my lord, 126, my lord. At page. Now, my lord, section 126 says, a bequest upon impossible condition. The bequest upon an impossible condition is void. Hence, my lord, this probate application has to be filed, my lord. Subsequently, only the estates would be, as per the will, would be divided amongst the legal heirs, my lord. Now,
Who has appointed you as executor?
my lord, the testator, testator of the will.
That is why, my lord, we were waiting, we have served a notice that you please file a probate case within the limitation period. And they did not do it, my lord.
My lord, we are ready to file the probate case subject to all the parties must bear the expense of the probate. My lord, now this condition is there. My lord, if there is money in the bank account, my lord, then it may supplement the probate proceedings. However, if there is no money, my lord, I submit that the parties may bear the expense equally now. That is my only suggestion.
Okay, how much money is left? The bank will not tell anybody.
Yes, that's why, my lord, the direction was passed by coordinate bank.
Okay, let us know from the bank.
Yes, only.
No
That will
bank
be
is, then it will serve the purpose.
Yes, my lord.
Heard Mr. R. Chakraborty, the learned counsel for the applicant. Learned counsel for the appellant. Also heard Mr. G. Imtiaz, the learned counsel for the respondent. It appears that by order dated 5/8/2026, this court had directed the manager of the Punjab National Bank, Maligaon branch, to furnish the account statement of bank account number 48458900100000151, which was in the name of the deceased. What is the name of the deceased?
My lord,
Late
Shambhunath Ghosh.
late Shambhunath Ghosh. However, stop. The learned. However, there is no indication in the office note or in the record that the copy of the said order has been.
My lord, we have sought, my lord. This is the copy with the advocate of the Punjab National Bank, my lord. On 13/8. Mr. A. Parvez.
Has been communicated to the Manager of Punjab National Bank. Stop. The learned counsel for the appellant submits that the copy of the order was furnished to the Standing Council of Punjab National Bank on 13/8/2026. However, no intimation has been furnished regarding the bank account of the deceased as was directed by this court. The registry is directed to reflect the name of Mr. A. Parvez, Standing Counsel, Punjab National Bank, in the cause list against this case and list this matter again on short dated again. 14th of September. You intimate Mr. Parvez orally. On the next date when he appears before the court, we will issue instruction to him on that day.
Deeply apology. Lordship, item number 46. Both the appellant as well as the insurance claimant have missed the bus. Your Lordship, as per last order, the name of the that has not been reflected in the cause list.
46 key order, I say. Okay. Show the name of Mr. T. Kolita, the learned counsel for appellant, and Mr. D. Mondol,
My name is reflected.
learned counsel for respondent number 1, 2, 3.
Your Lord,
Remaining will
Your
remain.
Lordship, this is stay application, so Your Lordship give a short date.
When is the next date? 16
Can it be
September.
on 3rd of, because appeal has been admitted on that day, Your Lordship.
16 September. Wait till 16 September.
Oblige.
I'm taking it short. Yes.
May I please, my lord. My lord, this is a issue, my lord. I'm being assisted by Mr. N. Khera over VC, my lord. My lord, this is an issue in the last order, my lord.
How will he assist online?
My lord, my other engineer is on legs, my lord. She's adjourning and matter. So I may, my lord, may take it after some time.
What is the matter?
My lord, this is regarding the Indian Electricity Act, my lord. This is a judgment and decree passed by the learned civil judge. Karimganj, Civil Judge Senior Division, Karimganj, in title suit, whereby compensation of 11,09,701 with 6% interest has been granted to the respondents. Now, my lord, in the very first, my lord, the first issue, my lord, in the last order was there was a direction to satisfy the court as to the regard to the issue of maintainability of this writ petition under Article 227. This decree has been passed by the learned civil judge senior division without any jurisdiction. There has been an inherent lack of patent jurisdiction in this matter, my lord. Why, my lord? If my lord comes to the Indian Telegraph Act,
Now, before coming to that, if I may mention Section 9 of the Civil Procedure Code, my lord. All suits to be tried unless barred, either by a special statute or any other law. Here, my lord, in the Indian Telegraph Act 1885, Section 16, my lord, and subsection 3.
Indian Telegraph Act.
If I may read it, my lord. Section 16, subsection 3.
Yes. Yes.
Section 16, subsection 3 says, if any dispute arises concerning the sufficiency of the compensation to be paid under Section 10, Clause D, it shall, on application for that purpose by either of the disputing parties to the district judge within whose jurisdiction the property is situated, be determined by him. Now, by this act, my lord, the jurisdiction has been bestowed upon the district judge and no one else. No other civil court has been bestowed with this power to hear matters relating to the sufficiency of compensation under 16.3 of the Act. Only the district judge is to hear this matter.
In this case, whether any compensation was assessed under Section 10.
My lord, that is the second part. Fraud has been committed upon the civil court. These respondents, their husband and son, they have already received a compensation. They suppress these material facts. They filed a civil suit before the senior division, suppressing the fact that they have already, their husband and son for the same land has already received compensation from the district administration. We'll come to that after that, but first, the issue of maintainability under 227, my lord. Because this whole decree is null and void ab initio. Civil Judge Senior Division is not empowered to hear the issue of compensation under the Indian Telegraph Act 1885.
But it is a appealable decree.
My lord.
It is a appealable decree.
Otherwise, it is appealable. Otherwise, it had the issue been only due to fraud, under Section 47, we could have raised these issues before the execution code also, that this decree is null and void due to fraud or for any other reason. But here the main question is the issue of maintainability arises under 227 because there's lack of patent in jurisdiction.
The point of maintainability could have been raised in the appeal also.
My lord. But the situation here is that what the judgments of the Supreme Court says, once a court is not empowered to hear a case at all, it has no jurisdiction to enter. The subject matter of the jurisdiction is not bestowed upon a particular court. Then we can approach the High Court under 227 to get the whole decree declared null and void and set aside. I'll come to those judgments also, my lord. Yes. This is, my lord, 2017, 5 SCC 143. At para 27, 28, and 29. The last page, my lord.
Yes.
At para 27, my lord. At this stage, we deal with the direction of the division bench regarding compensation payable to the writ petitioner or, for that matter, to the state government. In the first instance, no such claim was laid by the writ petitioner in the writ petition or by the state government before the High Court. Furthermore, the High Court could not have taken this task to the district collector, which is contrary to the provisions of section 16C of the Telegraph Act 1885, which are extended to laying down of electricity lines. As per this provision, such an authority vests with the district judge. At 28, these are sufficient reasons to allow civil appeal number so-and-so of 2016 preferred by Power Grid by setting aside those directions. Ordered accordingly. We make it clear that if the writ petitioner feels that it is entitled to any compensation, the appropriate course of action is to file a suit before the district judge concerned for this purpose. It would also be apt to point out at this stage that the central government has framed guidelines under guidelines dated so-and-so in this behalf, which inter alia provide that the issue of compensation may be resolved having regard to the mode and manner of assessment of compensation as per the said guidelines. Therefore, it would always be open to the writ petitioner to avail the remedy as per the said guidelines. At 29, this appeal is filed by Power Grid in the case of Ram Naresh Singh. In this case, transmission lines are in district Sasaram in the state of Bihar. The complete work for laying down the transmission lines where 524 overhead towers have been erected by the Power Grid. Out of these, only one tower is located at the land belonging to Ram Naresh Singh. The dispute raised is with regard to the quantum of compensation, and as per the provisions of section 16 of the Telegraph Act 1885, it is to be settled by the district judge. Thus, for all the reasons given above in the case of Century Textiles and Industries Limited, this appeal of the Power Grid stands allowed and judgment of the High Court is set aside. My lord, here it is made it very clear that the only power to hear compensation issues is lies with the district judge and nobody else.
No, what happened in this case? What are the facts of this?
My lord, this is laying of telecommunications line.
In the instant case.
My lord, here, my lord.
Not the case which you are referring to, but the case which we are hearing.
My lord.
What are the facts?
My lord, facts is that the respondents filed a civil suit before the learned civil judge senior division, claiming compensation for the land acquired by us, the Power Grid Corporation of India.
Okay.
The husband and son of both the respondents have already been awarded compensation by the district authority in terms of the assessment made by the district authority and payable under section 10. Now they have suppressed all these material facts. They don't go to the district first, at the very first outset. First, they have to approach the district magistrate. If they are not satisfied with the quantum of compensation before by the district magistrate, they can come under 16th before the district judge. They have to file a suit there, and the learned district judge will hear both the parties before verifying and quantifying the amount of compensation payable to the claimants. Here, my lord, in this case, my lord, the civil judge senior division has no role absolutely, my lord, here.
Whether the suit was contested?
It was contested. We have taken a specifically regarding the maintainability of the suit.
How it was dealt with?
My lord?
How it was dealt?
It was all silent, sub-silent too. There's there's silence on this part. They have gone, the learned civil judge senior division has gone straight to the facts of the case without settling the issue of maintainability also. But
still the impugned judgment is an appealable.
Appealable, no doubt, my lord. That's why, my lord, I'll come to that.
When you have
when my lord, there's a patent lack of inherent jurisdiction.
No, but when you have other statutory remedy,
my lord,
to avail,
my lord,
why the powers under 227?
I understand I understand your query, my lord. My lord, now we have a issue of fraud also. Now we are not pressing for fraud beforehand because fraud can also be challenged, as I have submitted earlier. Under section 47, even in the execution stage, we can challenge the issue of fraud also, maintainability also, and lack of jurisdiction also. But here, my lord, this is, my lord, Magad Sugar and Energy Limited versus State of Bihar. This is by Dr. Dhananjay Chandrachud. Leave has been granted, my lord, at page 16 and 17, it starts at para 19.
Era?
Para 16. I'm sorry, para 19, my lord, page 16. Down below, madam.
Yes.
While a high court would normally not exercise its writ jurisdiction under Article 226 of the Constitution if an effective and efficacious alternate remedy is available, the existence of an alternate remedy does not by itself bar the High Court from exercising its jurisdiction in certain contingencies.
But this is the this is saying about writ jurisdiction. We are not exercising writ jurisdiction. We are exercising supervisory jurisdiction. Under 227.
My lord.
So 227's jurisdiction is different from 226.
My lord. Well, I'll come to that. This principle has been crystallized by the court in Whirlpool Corporation versus Registrar of Trademarks in Mumbai and Harbansal Sahani versus Indian Oil Corporation. Recently in so-and-so versus so-and-so, a two-judge bench of this court, of which one of us was a part, has summarized the principles governing the exercise of writ jurisdiction by the High Court in the presence of an alternative remedy. At 28, my lord, the principles of law which emerge are that one, the power of Article 2, it talks about 226, but exceptions to the rule at 3, my lord. Exceptions to the rule of alternate remedy arise where the writ petition has been filed for the enforcement of a fundamental right protected by Part 3 of the Constitution. B, there has been a violation of the principles of natural justice. And C, the order or proceedings are wholly without jurisdiction.
But this is about writ jurisdiction.
My lord. But there are two more judgments which I can satisfy, my lord. There are two more other judgments regarding 227. But first, my lord, may kindly finish with this. At para 20, this is my lord. 2023 Supreme Court Madras. The High Court, this is Madras, single bench of the Madras High Court. The last page, madam. This page 9 of 9. At para 22, the last page, madam.
Yes.
This court, however, has changed to add that breach of fairness as a doctrine can invite interference under Article 227 of the Constitution only if it upsets the substantial rights of a party who is victimized by such breach, thereby leading to miscarriage of justice. In Abdul Rashid Sahib's case, it is held when Article 227 is invoked, this court scans the judicial process applied in a litigation to ascertain the quality of prosecutorial justice and evaluates the consequences produced. Not all the mishandled procedure affects the substantial rights to litigate or defend or produce unfair results, as many may fall within the domain of the discretionary space made available to the courts subordinate to this court, where the procedure is mishandled or manipulated to produce an unfair result adverse to one of the litigants with the potential to impair the litigant's faith in the court. It will be a clarion call for this court to step in. This court's claim that it is a sentinel on the qui vive in protecting the rights of the citizens will then go hollow and weather-beaten if it compromises its constitutional conscience and forsakes its duty to correct a wrong in exercise of its powers under Article 227 of the Constitution. This is the soul of its supervisory power of identifying a wrong which holds the potential to imperil the public faith in the judiciary or challenges its own purity and effectiveness for its functioning, and then following it with curial measures. Fraud on court empowers the same court as well as this court to interfere in appropriate cases under Article 227 of the Constitution of India. In conclusion, this revision is allowed. My lord, there are 2-3 other judgments, my lord, which I would like to bring to your lordship notice. For that, my lord, I'll need another short date, my lord, so that I can satisfy my lord. But the whole crux of the matter is that, my lord, the learned civil judge senior division had no jurisdiction to entertain this matter, and any decree arising out of this orders of this court is null and void, my lord, and is liable to be set aside. Although we have alternative remedy in the form of filing a title appeal, my lord, it goes to the root of the matter, my lord. The learned senior division.
You want to rely on some other judgments?
My lord.
Yes, Mr. Hawk. Regarding prayer for adjournment.
Ultimately, they are praying for adjournment. No, my lord, it is not adjournment, my lord. It is further hearing. The matter can be disposed of either way.
When?
My lord, next Thursday, my lord.
So today we are not proceeding with this. Any objection? Heard Mr. R. Sharma, the learned senior counsel assisted by Mr. P. Foucault, Ms. P. Foucault, learned counsel for the petitioner. Also heard Mr. N. Hawk, the learned counsel for the respondent. Respondent number?
1 and 2.
1 and 2. Mr. T. R. Gogoi, appearing for respondent number 4, 5, 6, and 7. And Mr. M. Das, appearing for respondent number 3. While making submissions on the point of maintainability of the instant application under Article 227/ of the Constitution of India, the learned senior counsel submits that some time may be granted to him so that he can place before the court some more authorities in support of his submission regarding maintainability of the instant revision petition under Article 227. The prayer is stopped. The prayer is not opposed to by learned counsel for the respondent. Hence, same is allowed. Let this matter be listed again on 15th of September.
Is it a part?
No, no part, because there is the MA, RFA, the CRP, it will come to this court, but I am not keeping it part. Let this matter be listed again on 15th of September.
My lord, I'm assisted by Mr. N. Khera, my lord. He's on VC, my lord.
He has not assisted you. Assisted by Mr. N. Khera, the learned counsel for the petitioner. Okay, on 15th of September.
My lord, will be disposed of.
You want this to be kept as part heard?
My lord, I have no objection. I have no objection.
No part heard. It will come to this court only. 15th of September.
I have no objection.
If-
Obliged.
Obliged, my lord.
Lordship, this matter has wrongly been listed in the admission column. It was supposed to come on in order column. Services awaited, Lordship.
Heard Miss
Cave Rally.
K. Bharali, the learned counsel for the appellant. On perusal of the office note dated 31/7/2026, it appears that service report in respect of notices issued to the respondent is awaited. Stop. The registry is directed to place the postal track consignment reports of notices sent to the aforesaid respondents by speed post before this court on the next date fixed. Let this matter be listed 16th of September.
Lordship, there is an interim order in the IA.
The interim
Order dated 15/7/2026.
interim relief granted earlier shall continue till next date.
Deeply obliged.
None has appeared for the appellant on call. Let this matter be listed in the next week on a date to be fixed by registry.
Item 8.
I have filed an IA to substitute the petitioner as his died. But the IA has not been listed along with this appeal.
Heard Mr. F.Z. Mazumdar, the learned counsel for the appellant, who submits that an interlocutory application has been filed in connection with this appeal for substitution of the legal heirs of the deceased appellant.
Yes.
Deceased appellant. However, same has not been tagged with this record. He therefore prays for directing the registry to
IA number is there, Lordship. IA civil 2959 of the
place the IA numbers within bracket civil
2959.
2959/2026 along with this appeal on the next date fixed. Stop. The prayer is allowed. Registry to do so. Stop. List this matter again on 16th of September.
September. Can it be little earlier, Lordship? Because I just to dispute the IA.
16th September.
Item 9.
Yes, heard Mr. K.K. Bhatto, the learned counsel for the appellant. Also heard Mr. S.R. Gogoi, the learned counsel for the
Yes, no, one, two, and 3.
respondent number 1, 2, and 3 / claimant. This appeal under section 173 of the Motor Vehicles Act 1988 has been preferred by the appellant insurance company, impugning the judgment and award dated 1/10/2024 passed by the Motor Accident Claims Tribunal Margherita in MSC case number 14/2020, whereby the appellant was directed to pay a compensation amount of rupees 17,77,600 to the claimants along with an interest at the rate of 9% per annum. I have considered the submissions made by learned counsel for the appellant and have gone through the grounds stated in the memo of appeal. Stop. This appeal is admitted. Stop. Let the records of MSC case number 14/2020 be called for from the concerned tribunal. Stop. The registry shall take steps for requisitioning the records. Stop. Let also the notice be issued to the respondents. Since Mr. Gogoi has already appeared for respondent number 1, 2, and 3, no formal steps is required to be taken for issuance of notice to the said respondents. You have received memo of appeal.
Yes.
However, as regards the remaining respondents are concerned, the appellant shall take steps for issuance of notice upon the remaining respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 30th of September, list according.
I protest, will deposit 50%.
Any objection?
No.
Heard Mr. K. Bhatto, the learned counsel for the applicant. Also heard Mr. S.R. Gogoi, the learned counsel for the opposite party claimant. This interlocutory application has been filed by the applicant insurance company in connection with MAC appeal number 436/2026, praying for stay of execution of the judgment and award dated 1/10/2024, passed in MAC case number 14/2020 by the Motor Accident Claims Tribunal Margherita, whereby the applicant insurance company was directed to pay a compensation amount of rupees 17,77,600 along with an interest at the rate of 9% per annum. Stop. The learned counsel for the applicant has submitted that the aforesaid judgment has been impugned by the insurance company in the connected MAC appeal number 436/2026. Stop. He also submits that the insurance company / applicant is agreeable to deposit 50% of the awarded amount before the registry of this court as a condition for grant of stay of execution of the impugned judgment and award. Stop. Mr. S.R. Gogoi, the learned counsel for the opposite party / claimant, submits that the claimants opposite party do not have any objection to the grant of stay subject to the condition imposed subject to the condition of payment of 50% of the awarded amount. Stop. Since the claimants have not objected to the grant of stay, the notice to other opposite parties in this interlocutory application is hereby waived and this interlocutory application is allowed. The execution of impugned judgment and award passed in MSC case number 14/2020 is hereby stayed during the pendency of the connected MAC appeal number 436/2026, subject to deposit of 50% of the awarded amount by the applicant insurance company before the registry of this court within a period of 4 weeks, 6 weeks from the date of this order. Stop. On such deposit being made, the said amount shall be disbursed by the registry to the
Subject to partition.
to the opposite parties claimant, after proper verification, subject to furnishing of a bond equivalent to the amount to be disbursed to them. With above observation, this interlocutory application is accordingly disposed of.
And it's also analogous methodology. In this case, the claimant has appeared for the respondent number 1 to 4.
Then also same order. IA separate order. In this 9 and 10 similar orders. Only verify the Who are the claimant in 10?
This one 1 to 5.
In 10, instead of
This one 1 to 4.
in earlier application, it was 1 to 3. In 10, it is 1 to 4. Remaining thing remains same. Only the quantum, verify the quantum. I disposed of.
Item 11.
1 to 4.
11 is also same.
6.
11 is also same. 1 to 4.
1 to 4.
1 to 4.
I disposed of.
Item 12.
Must oblige.
Meet with notice and record.
Third, Mr. S. Das. ये अभिषेक रेड्डी कर सकेंगे ना? Issue notice, call for record. The within 7 days steps take. Release this matter on 30 September.
37.
30 September.
I live.
Item 14.
Then, please, Your Lordship, we are preferring this appeal against judgment on award dated 7/7/26, passed by the MSHC.
Same,
tribunal.
Mr. P. Miss P. Foucault. Issue notice within 7 days. Take steps. 30 September next day.
So there's also a stay application.
IA, we are issuing notice now. In IA also issue notice.
Right, Your Lordship.
Appeal admit. Call for records. 30 September next day.
Pleasure.
14.
I am appearing on behalf of the caveators.
Your Lordship, kindly adjourn the matter for today. My senior counsel's presence is necessary in this case.
Why? Why it is necessary?
It's necessary, Lordship,
No, why it is necessary?
because a caveat has been filed. That's why.
You are pressing for interim relief.
No, Lordship, we are not placing today.
Then we'll issue notice. We'll admit the appeal. Is there any stay?
No, Lordship, there is no delay.
Is there any stay application?
Yes, stay application is there.
We'll decide the stay application on the next date fix. We'll issue notice. Heard Ms. D. Goswami, learned counsel for the appellant.
Lord,
Oh.
can take it up next week, Lord, someday if senior representative, Lordship can
Okay.
take up both the matters together.
No, we'll take it up on 15th or 16th September. No, in the 30 September.
As per your Lordship.
Heard Ms. D. Goswami, learned counsel for the appellant. Also heard Mr. R. Dubey, the learned counsel for respondent number
1, 2, and 3, Lord.
1, 2, and 3 / claimants. This appeal under section 173 of Motor Vehicles Act 1988 has been preferred by the appellant insurance company, impugning the judgment and award dated 4/6/2026, passed by the Motor Accident Claims Tribunal number 2, Kamrup Metro, in MEC case number 2032/2023, whereby the appellant insurance company was directed to pay a compensation amount of rupees 52,22,532 along with interest to the claimant respondents. I have considered the submissions made by learned counsel for the appellant and have gone through the grounds stated in the memo of appeal. The appeal is admitted. Let the records of MEC case number 2032/2023 be called for from the concerned tribunal. The registry shall take steps for requisitioning the records. Let also notice be issued to the respondents. Since Mr. Dubey has appeared for respondent number 1, 2, and 3, no formal notice is required to be taken for issuance of notice. No formal steps is required to be taken for issuance of notice upon said respondent. However, you have received the copies.
Yes, I have received.
However, as regards the remaining respondents, the appellant shall take steps for issuance of notice upon them to them by speed post as well as the usual mode within 7 days from the date of this order, returnable on 30 September. Issue notice in IA also. Show the presence of Mr. Dubey in IA in 1/1/23. 30 September.
Deeply.
Deeply organized.
Item 41 from supplementary list.
Lordship, in the same matter, Lordship has passed an order to deposit 50% awarded amount, and same shall be disbursed by the claimant.
No, claimant is not there. In IA order has been passed. No, but where is the appellant? We'll take it up next week. None has appeared.
Even they have not furnished us copy also.
Okay. None has appeared for the appellant on call. Heard Mr. What is your name? D. Mr. D. Khair Katari appears for the respondents / claimants. He submits that the appellant has not furnished copies of memo of appeal as well as interlocutory application to him. Stop. The appellant is directed to furnish copy of memo of appeal as well as the interlocutory application to the
41. That's why I am for the appellant.
show the name of Mr. S.P. Sharma. You furnish the memo of appeal.
Lordship, a memo of appeal already furnished. I think he's asking for the IAs. For the
IAU for furnish. We'll take it. Let this matter be listed again. 9th of September.
Obliged.
Finish.